Hi. So, one of the most important issues in the Murdaugh trial to date is the issue of character evidence, or Rule 404. If you've been listening to the trial, you've probably heard a lot of Rule 404 and related motions by the parties. Um, so, a lot has come in this character evidence, and we're going to go through that in this video. But I thought it was important to talk about what it is in South Carolina, not only because of how it's impacting the evidence that's coming in and ultimately what the jury may find persuasive in coming to its verdict, but also how that will come into play as to what has come in and how that'll affect any potential appellate issues. So let's get into it and let's figure out to learn a little bit more about South Carolina Rule 404. Okay, so first we'll go to the rule itself. So, here, the general rule in South Carolina, as well as the federal rules of criminal procedure, is that, of criminal rules of federal evidence, excuse me, is that character evidence generally about a person's character or trait is not admissible for the purpose of proving that what they did is in conformity with that trait. So it's propensity evidence. You can't say, well, they lied about this, they must have lied about that. And so that type of evidence, that's the general rule, is that it's not allowed to be in. We don't want to convict people based on, conformity of how they may have acted in the past. We want to convict people and based on what the evidence is for that particular charge. Similarly, evidence of other crimes, wrongs, or acts is not admissible to prove that the character of that person acted in conformity therewith. So just because they've done something in the past that was bad doesn't mean that they did it this time. So that's the general rule. Now, there are exceptions, which we'll go over. And of course, there are exceptions because, as we've seen, this type of evidence has already come into the case. So, just to recap, here, we've got two types of character evidence. We've got the first type we talked about, the character of the accused. Remember, it's not allowed unless the defense opens the door. And that's Rule 404A. The other type, that other bad acts, crimes, etc. If you've taken the bar exam, you probably remember bar study review. This was called mimic evidence. But in any event, that's 404B evidence. And up until today, or actually yesterday, up until this week of the trial, week 4, most of the evidence we had seen that was character had come in under this 404B, or other acts or bad acts or crimes. But those are the two types. So going back to the rule here, here's again the general rule. Now, with respect to the other bad acts, which we're going to cover first, because as I mentioned, that's really what's come in for the most part up until recently, is that you couldn't get into anything unless there are also two standards. You have to first show that it's the type of evidence, this type of other bad acts that are allowed under South Carolina law. So it's not just any other bad act, any type of crime. It's got to meet the test in Supreme Court. And that test in Supreme Court is laid out in the Supreme Court case of State v. Lyle, very long standing case in South Carolina, and really not much different, honestly, to most states. But again, here we talk about the general rule, which here is saying, look, this is a long standing rule that universally recognized and firmly established in all English speaking countries. That I didn't know, but that's good to know. But in any event, I'm pretty sure it's definitely applicable in all of the states in the United States, and definitely federal. But in any event, that this concept that evidence of other distinct crimes committed by the accused may not be adduced merely to raise an inference or to corroborate the prosecution's theory of the defendant's guilt of the particular crime charge. So again, well ensconced in Supreme Court law in South Carolina. So what can we get in? Here is what we can get in. Here is the test. So the test is that basically if your evidence of other crimes is competent to prove the specific crime charge. So you could use other crimes to prove this crime. So in Murdaugh, we could use some other crime or bad act to try to show that they committed the thing here, which is murder. When it tends to establish these things: motive, why did he do it? Intent, wasn't an accident, he tended to do it. The absence of a mistake or accident, to show a common scheme or plan, embracing the commission of two or more crimes so that they're so related, or the identity of the person charged, if that wasn't known. So those are the 5 reasons in South Carolina where you could get into evidence other bad acts or crimes to show that the defendant in this particular case did the thing, committed the murder. So in our case, in Murdaugh, what has been shown up to date is motive. And so we'll go through each of what has been put forth by the prosecution thus far. But the key for each of these items is they need to demonstrate that it's the motive evidence is related to the killing. So we'll go through those and see if what has come in as motive evidence, what do you think, is that related to the motive for the killing? Or is it motive or something else? So that's very, very interesting. The other thing to mention about the Supreme Court rule is that based on what you can get in, first of all, not every bad act can come in or any conviction. And now, if it's a conviction, it can come in. But if it's another non-convict, if it's a crime that hasn't have a conviction that would be subject to judicial notice or some other bad act, it does have to be established by clear and convincing evidence. Here, I don't think the prosecution would have a problem with that because we've seen so much testimony and so much foundational evidence on, for example, the fraud with the law firm. We had the accountant come in, the paralegal, one of his former law partners. We had the testimony with the fake Forge account. So there's been a lot there. I think that it probably could show clear and convincing evidence. Again, this is just my opinion. This is not legal advice, but I think that that one is probably there. So I think the second point, which we'll talk about in a little bit, is the kicker, though, kind of the savings clause, so to speak, is that even in any event, if the evidence is established by clear and convincing evidence, and it's it's regarding one of these allowed types of evidence like motive or identity, etc., that we just talked about, even if all that's cool, if the prejudicial effect of that evidence substantially outweighs its probative value, it's not going to come in. And that's just a rule for a criminal, that if it's too prejudicial, we're not going to let it in. I think that's going to be the kicker on appeal, but we'll get to that. So going back to the evidence, what have they shown thus far? Okay, so here I have, let me get to my copy here. Okay, so what that's come in so far on character evidence of other bad acts or crimes, we've had all of the evidence about the theft to his law firm. So that included the testimony of, again, this firm's CFO, his paralegal, his former law partner. We had the testimony of the real Forge Consulting, which would have been the service provider that helps out with settlements. All of that evidence came in because of motive. At least the judge has allowed it in for motive. We also saw all of the evidence about the theft to his clients, including the testimony from Gloria Satterfield's son about the theft of millions of dollars from that family, related to the judgment that they, the settlement that money that they received from Alex Murdaugh's insurance company. Again, how does that relate to motive? Then we had the evidence about the theft to his best friend regarding the trust money. Remember, like, all the evidence about, Alec, like, lying and telling his paralegal in the firm that he hadn't gotten the money yet, but his best friend had, who he was co-counsel with on a case, had given his portion of the money, and all this kind of basically trying to, like, hide the money because Alex was trying to allegedly, keep it for himself and not deposit into the firm because it's the firm's fees, and all of that stuff. And actually, to this day, his best friend is still owed, I think, $190,000 from that whole debacle. So that evidence came in. And also, we had evidence from the attorney handling the Mallory Beach family in the boat case, who was suing Alec personally. Remember, it wasn't just his insurance coverage. He was being sued personally and was being very aggressive about it. Bad acts. All of that has been admitted to date based on the prosecution's motive theory. Okay. So going back, there's motive. But remember, we have another type of character evidence that can come in, and that is character evidence based on the accused or the victim or witness. But here, what we've seen thus far that has just come in this week is evidence about Alec himself, the accused. So going back to the rule, again, we're going back to the rule 404. And here, that's the rule 404A. So again, evidence of a person's character is not going to come in unless evidence of a pertinent trait of character offered by an accused. That's called opening the door. And what that's done is that has opened the door to all sorts of evidence. We have got evidence including the 911 call from that day of the roadside shooting. We have his interview with the first responders that picked him up at the hospital. Then we have his interview with SLED, including that audio interview we heard, where Alec was in the rehab facility at that point, and he was with his lawyers, and they gave an phone interview with SLED, and all the stuff that came out about in that, all that information about his drug addiction, all the money that was found in Eddie Smith's account, and the search at his place of where he lives, the testimony from Blanca that Alec had called her that morning of the roadside shooting wanting insurance information. The call, as I mentioned, the call with Alec where his lawyers were with him, where he's talking about the whole plot and admits to the plot, and including his plan that he was trying to he was allegedly hiring Eddie to kill him, so that Buster could have the life insurance and be taken care of. So all of that evidence, I mean, it's like a mini trial at this point. All of that evidence came in because the judge found that the defense opened the door with that line of questioning. So as you can see, a lot of evidence came in just by that one thing. So I think going back to kind of where we are, I thought it would be helpful to recap what the prosecution is trying to argue with respect to all this type of character evidence that's come in, and what the defense is going to counter back, either already has or what I think they're going to say. So first, with respect to the prosecution, I think the prosecution is going to argue that with respect to all the financial information that they got in through the other bad acts and crimes prong 404B, they're going to show, look, this was the motive, and the motive is the gig was up. He was stealing. He had this whole like elaborate scheme going on with theft from his clients, and it was starting to come to a head because the law firm, the morning of the murders, confronted him about this missing money that was supposed to be in the firm, and why wasn't it in his trust account, and that involved his best friend and all of that evidence. You also had the upcoming court hearing on the civil boat case, and so this idea that basically things were coming to a head and his fraud was going to be discovered, and therefore he had to kill his wife and son to take the heat off him. I mean, that's basically my understanding of what I think the prosecution's theory is for motive in order to get all of that other financial information in. With respect to the other information that's coming in the past few days on the roadside shooting, of course, their argument there is, look, the defense opened the door. And of course, they won that argument, and the judge allowed that evidence in. So, as far as the defense goes, on 404B, the financial evidence, they're going to first they have argued, and they haven't won because it's come in, but their argument has been it doesn't show motive, it's extraneous, it's not related, it's separate in part, it has nothing to do with a murder. This is all evidence about other things that he's admitted to. Just because he's a bad guy and he did all this fraud doesn't mean he killed his wife and child. And should not be going. It's not motive evidence, it's propensity evidence. So that's their argument there. And then if they lose on that, then of course they're going to try to argue, well, you shouldn't have let it in anyway. And that's why they keep reiterating their objections under 404, because they're going to argue, look, this is all too much. This you've gone too far. It's not probative anymore. It's too prejudicial. So they're going to argue that. On the 404A, the character evidence, where they argue that Alex's team opened the door. Of course, we already heard the defense argue to the judge, we didn't open the door. But in any event, that so far that was not a winning argument. So that might be something on appeal. But also in the alternative, they will argue that the evidence should in any event be excluded under Rule 403. Rule 403, which we'll end with, is this. When Rule 403 holds that if it's too prejudicial, it needs to come out. And so that's what their arguments are going to be. And actually, we'll end here real quick on Rule 403. So what Rule 403 is, it's kind of like the savings, as I mentioned, like the savings rule. It's like if everything else fails, but it's kind of like the last argument really, is that even if something's relevant, it meets the clear and convincing evidence standard. It's relevant. It goes to motive, or the defendant opened the door. It's all improper. The court can still exclude that evidence if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues. I think unfair prejudice, I think the defense is going to for sure argue. They have been arguing. Confusion of the issues, I can see that. I mean, I'm confused a little bit. Or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. I mean, these are all arguments that I think the defense could make. And we'll kind of have to see how it goes. And the judge did mention when he allowed the roadside shooting evidence in, that he understands that under Supreme Court case law in South Carolina, that even if it comes in because it opened the door, it doesn't mean it's going to be in forever. And there could be a stop. And so I think, we'll have to see if it becomes too much. But in any event, that would be what the defense would argue. I think just to conclude, I think that what I'm concerned about, particularly with the roadside shooting, I'm just concerned we're in like I think we're in like mini trial 3 now. I mean, I don't know. I just feel like this has gone too far. I mean, I personally feel, again, and this is my opinion, this is not legal advice, but I think that the evidence that was around close in time to the murders, the financial evidence, I think that's a pretty, I mean, it's one, I mean, the prosecution's won that argument, but I think on appeal, have to see where it goes. But I do think that there is a good argument for the prosecution to say, look, the jig was up and it kind of like everything exploded. Um, but then when you start going backwards, like back in time too long or forward in time too long, I mean, I just think the roadside shooting thing is just, I personally think it might have gone too far. But we'll see. What I can say for sure is that I think Rule 404 and all of these issues that we've just been going through very briefly, I think for sure if Alec Murdaugh is convicted, I think personally this will be one of, if not it'll be one of the most important things that would be considered on appeal. And so it'll be really interesting. But in any event, what do you think? Do you think that all that financial evidence shows motive? Do you think that um, the fact that he stole the money from the firm, that he um, was trying to hide money, he was oh my gosh, I forgot all the evidence about the fake account at the banks, and I mean, do you think all that shows motive for murder? I mean, I can see both sides. Um, Yeah, it's so interesting. But anyway, let me know what you think in the comments below. We'll have to see where this goes. But thanks again for joining, and I'll link some of my some other videos that'll be interesting. It's one of my more recent videos on the Murdaugh trial. And if you could like and subscribe, and I hope to see you back in my next one. Have a great day. Thank you.